From supplementary list, item number 1 for pronouncement of order.
Who's appearing?
Mr. Nombri is the counsel for it.
I'll read out the operative portion.
Yes.
On the basis of the above observation, this application is found to be unjustified and without merits. Accordingly, the same is hereby dismissed. So the main case la list lang to.
Item 3.
The main petition.
Yes, I think.
Please, Your Lordship. Your Lordship, I beg to mention item number 11, 12, and 13.
Why?
For 2 weeks' time, Your Lordship, was conducting counsel is suffering from sore throat, Your Lordship.
You are there.
I'm not prepared with this one.
You can write it down and you can relate. You can just relay whatever he says. Unnecessarily, this is. Yes, who's appearing?
No objections, Your Lordship.
You are for
11, 12, and 13, Your Lordship.
13. You are for 14.
Your Lordship, in fact, items number 10 to 14 are similar matters.
But who's appearing in 10? You are the petitioner.
Yes, Your Lordship. Your Lordship, it's Yadav, SS Yadav.
We'll see as far as 10 is concerned, since nobody is here. If he says that it will be taken up on the next date, then we'll see. So as far as 10, 11, 12, 13, 14, 2 weeks then.
Right, Your Lordship.
Or pray made by the respondent, not objected to by petitioner. List is matter after 2 weeks.
Item number 7, Lordship. Item number 7.
Yes.
Actually, I pray for some more time because after that accident, I had to go for the therapy session. I just completed.
You had the accident?
In the last occasion, I had an accident. I fell down from the scooty, from the back. So I have to go for the therapies. So I just recovered. So give me some time, then I'll try to furnish my ethics.
On pray made by the petitioner, seeking accommodation on grounds of personal difficulty. Matter is adjourned. Discuss him after 2 weeks. 2 weeks.
From supplementary list, item number 2.
Well, this matter that pertains to the suspension of the same of Iman Oswong Malot. This is the third round we have come up because all information that was given to us was in piecemeal Malot. So we have tried to serve the respondent number 4, who is the present acting same Malot, but the council has refused to take notice Malot in this case. Malot, the inquiry has already started Malot. Only small one prayer Malot. Pending this writ petition, Malot, the inquiry may be stayed and Malot will examine the entire matter. And whatever the outcome, Malot, then we will file a miscase also, Malot, to that effect. Because already I have received a notice for inquiry, Malot.
You have been suspended.
Malot.
inquiry has been initiated
Initiated. my lord.
and has proceeded.
Yes, my lord. Notice has been given to me also, my lord. So what I'm praying, my lord, pendency of this writ petition, my lord, if the inquiry may be stayed and whatever the outcome of this writ petition, my lord, then we will see.
Have you come against the process of the inquiry?
My lord, almost we have challenged everything, my lord, right from my suspension till
You know very well, you see, as far as this court is concerned,
my lord.
it will look into the irregularity of the process,
Your lordship.
not on the merits of the process per se.
My lord. But my lord,
So,
even
not on the merits of the inquiry procedure.
your lordship. But my lord, what I would humbly submit is that my lord, if your lordship examine my suspension order, it's a very, it's an order, my lord, very cryptic order and very mechanical, in a very mechanical way it has been passed, my lord. Whatever in the impugn order of suspension is there, my lord, the entire matter is pending with the discounsel, my lord. There's nothing on my part to do anything, my lord. In spite of that, they have suspended me, my lord. So that aspect, my lord, if my senior can file the reply within 2 weeks or 3 weeks, whatever time, my
Well,
lord.
within 2 weeks, because in the earlier round also, they had withdrawn the writ petition and we had filed a counter. So we'll need a week's time to file a counter.
We'll let them file a counter.
Yes.
And we'll look at the matter in its entirety.
So we will take steps on respondent number 4, my lord, if that's the case.
2 weeks.
2 weeks.
Heard Mr. L. Cream, the counsel for the petitioner, who has submitted that on this petition being moved today before this court, notice has been effected upon the respondents number 1, 2 and 3 respectively.
1, 2, 3.
However, it is prayed that notice may be allowed to be issued upon the respondent number 4. Since Mr. T.T. Dingro, learned senior counsel, you are a special counsel, isn't it?
Special counsel.
And special counsel, KHDC. Since Mr. T.T. Dingro, learned senior, assisted by, has entered appearance on behalf of the said respondents 1, 2 and 3. Accordingly, no formal notice is required to be issued upon such respondents. The notice upon the respondent number 4 is directed to be issued, the same returnable within 2 weeks. In the meantime, as prayed for by Mr. Dingro, the counter affidavit on behalf of the respondent 1, 2 and 3 may be filed within the next date fix. If such counter affidavit is filed within the next returnable date with a copy served, duly served upon the petitioner is at liberty to file a rejoinder if so desired. This matter according.
Item number 3.
Lordship, in this matter, I'm required to file my rejoinder, Lordship. I'm praying for 2 weeks' time.
We have already filed our affidavit on behalf of the counsel.
Who are the respondents here?
The counsel and the complainant, the private respondent, Lordship. All the respondents have filed the affidavit, Lordship.
All respondents.
All respondents have filed.
Mr. M.L. Nupur, learned counsel for the petitioner, has submitted that some more time may be allowed for the rejoinder to the counter affidavit filed by the respondents to be filed. We allow place this matter up to 2 weeks.
Thank you, Lordship.
From daily list, item number 1.
May I please proceed?
Yes.
I have an instruction to withdraw this bail petition because the petitioners are willing to try in a trial court, Lordship.
They want to try in the trial. My lord, our case diary is.
It is original
No, my lord,
copy. So would you require this?
Yes,
to be
my
done?
lord. Yes, my lord. This one also, I'll hand it over back to my IO.
Mr. General Counsel for the petitioner has submitted that he will be allowed to withdraw this, that the petitioner may be allowed to withdraw this petition. Accordingly, on prayers who made, this petition is dismissed, hereby dismissed as withdrawn. The copy of the CD produced by the state respondent is hereby returned to Mr. S. N. Gupta, Leonard, additional PP.
Yes, obliged, madam.
1 and 2 connected with the lordship.
Similar.
Master lordship.
Item number 3.
my Lord has heard this matter before concluding the argument of learned AG. Lordship rose from the bench. So I prepare, Lordship allow me to prepare the brief written submission as I prepare, my Lord.
My Lord, we had to submit our bullet points written argument in this regard.
The argument has been completed?
My Lord, yes. It was heard on the last
oral
occasion.
argument completed?
Lordship has heard me and the Lordship has heard the learned AG. But before he concludes his argument, about to conclude, Lordship rose up. So if they don't want to further argue the case, I'll just clarify with 2 points only and submit the written argument. Lordship may proceed the matter for judgment. So I'll just give a short reply if their side is completed. I'll just point out two paragraphs.
Which means that, perhaps that
substantially has completed.
You have completed your argument?
My Lord, if the matter has to be heard, my Lord, AAG can argue again, my Lord, because it was not exclusively heard on that last occasion. So basically, we were confined to limited points. But Lordship,
you'll be allowed to. You will be allowed to complete your argument if you feel that there are some more points to be.
It can be argued, my Lord, if Lordship permits and is there sufficient time. And because on the last occasion, Lordship had to go to the other bench, so which is where the matter was confined to certain points.
Oh, Mr. Sulaisi.
Lordship, I'm supposed to make a note of argument, Your Lordship. I have not done it. If Lordship allow me some time, Your Lordship, I'll.
But you have not completed your oral argument.
Lordship, yes, only just I have completed only to place one judgment, Your Lordship, and that is a judgment from the Madras High Court, Your Lordship.
So Mr. Sangresu is ready with his written argument. You are ready. So you file your written argument.
Lordship, yes, we'll file it. If Lordship kindly allow us 2 weeks time, Your Lordship.
Well, that means if learned AG is not willing to proceed further oral arguments, in that case, I may give a short rejoinder and allow both the party to submit the written argument and proceed for judgment. If they don't want to advance further argument, oral argument.
I'll make a note of submission, Your Lordship. Kindly allow us 2 weeks time, Your Lordship.
In that case, may I just point out only one annexure? Yes, then Lordship allow us to proceed for submission of the argument.
Oh, this is that Pokso.
Lordship, yes, Pokso. He is a teacher of a.
Teacher.
He's a
teacher of a government girl high school, Jill Road, Your Lordship.
What is the stage of the?
My Lord, the evidence appears to have been concluded. Hearing is yet to be done.
Final hearing will take place on 26/11, Your Lordship.
Yes.
In the meantime, he has been placed under suspension.
Yes, more than 5-6 years now. He's under police suspension.
So you have come against the
order
suspension.
The process of suspension
order. I'm challenging the suspension order beyond 90 days.
Okay.
Beyond 90 days, Lordship kindly recollect. The 90 days benchmark was laid down by the Supreme Court in Ajay Kumar case.
But you see, Mr. Sangresu,
yes,
maybe you see things may have turned out that because of the proceeding in the criminal case taking quite some time,
yes,
the process of the suspension or the inquiry process has taken some time. Like you said, the suspension order has lapsed in the meantime.
Yes.
So let's say, for argument's sake, that this court would agree with you. So the suspension order is set aside.
Yes.
Now what happened?
My Lord, in that event
he cannot resume service.
No,
because of the fact that he is, involved in a criminal trial.
My Lord, if Lordship is satisfied my argument, set aside the suspension order, then he'll come back to service. He will continue to face the criminal case. If he's convicted, he'll be out from the service again. But the law is very clear. Departmental proceedings and criminal proceedings can go simultaneously. And Supreme Court has held.
Yes, that is true.
Yes, that the department cannot await the decision of the criminal case. Now, Supreme Court only put to condition that if the government submit a charge memo to the accused person or to the delinquent, within 90 days. And when they submit that charge memo within 90 days, government deem it fit, they can pass an extension order. In view of the pendency of the criminal case, we hereby extend it. So within 90 days, they can do that. Supreme Court said that if the department failed to place a charge memo to the accused, to the delinquent person within 90 days. Therefore, in that case, continuous suspension beyond 90 days is illegal. Therefore, this is my case, my lord. And Lordship has heard us both of us at
But
length.
their case is that the extension is already there.
There was a charge memo, Your Lordship.
Therefore, learned EHE has placed two vital points. Charge memo was served already, and number two, extension is already done. So I'll give that short reply only to that extent. Other low points, Lordship has heard both of us.
And because of the pendency of the criminal, Your Lordship, the DP has been kept on hold, Your Lordship.
That is
because identical facts, Your Lordship.
Right.
No, but that you see, as Mr. Sangresu has pointed out,
It can go, Your Lordship, but there are certain decisions, Your Lordship. If identical facts, Your Lordship, same witness who will be examined, then one has to be kept on hold, Your Lordship.
Well, that they can do, my lord, my humble submissions.
It is true, Your Lordship,
within 90 days.
Both the proceeding can go on, but
if
there are identical facts and the same witness, Your Lordship, and then the charge is serious, then one has to be kept in hold, Your Lordship. Lordship, I think the judgment of Captain Anthony case, Your Lordship.
They can keep on hold departmental proceedings and allow me to face the criminal trial, provided they issue a charge memo to me within 90 days. Number two condition is they pass the extension order.
That
say the similar nature of case, similar allegations, similar materials are against you, face the criminal trial, we will keep the you will keep the department proceeding in abeyance. They can do. Supreme Court said if they do not serve a charge memo within 90 days, and if they don't pass an extension order, suspension cannot continue beyond 90 days. That is my case. Had they served me a copy, charge memo within 90 days, and had they passed the extension order, I don't have any case. I bow down. But my case is otherwise. Lordship may kindly see page number 21, where learned EHE has pointed out that the charge memo has already served. But I'll just point out, I'll just take 5 minutes, and Lordship may allow both of us to. Because we don't need to repeat the other aspects that we have already advanced argument. It may go in a written.
21.
My lord, the suspension order is page 21. Page 21. And my lord, the date of the suspension is 15 September.
Yes.
Now, 30 days will be expired on or before 15, 16, 17 December. But the issue of short course, Lordship kindly come to page number 32. It bears the date 2nd Feb 28.
This is the show cause notice.
Show cause. And the containing a statement of allegations, that is the argument advanced by learned EHE, page number 33. The state respondent is claiming that they have served a charge memo. Now, admitted, Your Lordship, they have served this copy after 30 days, after 4 months. So it is beyond the 90 days benchmark laid down by the Apex Court. And that too, my lord, this was issued on 2nd February, and page number 30, Lordship can see. The same disciplinary authority constituted the 2 members inquiry committee. Page number 30. 30.
Yes.
Well, same date, same authority. Therefore, once the disciplinary authority constituted the departmental inquiry committee, 2 members committee. 2 members committee is supposed to issue me a show cause containing allegation of charges, memorandum of charges, allow me to file my show cause, along with the incriminating documents, the witnesses. I would enter into my defense and face the inquiry. An inquiry officer will give a report. A report will be placed before the disciplinary authority. The disciplinary authority will give me an inquiry report for my final representation, and they can pass final order. Now, therefore, assuming that this is a proper serving of memorandum charges, it is admitted beyond 90 days. So it is against the Supreme Court order. Secondly, this is not in fact a charge memo or memorandum of charges, because this is a formation of the formation of the inquiry committee. Therefore, my lord, this is beyond 90 days, so it is incorrect, impermissible. Now the extension order, second point, the extension has been made already. Now that one is that they have annexed in the affidavit, additional affidavit. Page number 5, additional affidavit filed on 28/2/2024. My lord, the extension order was passed on 28 August.
Yes, moment.
Page number 5, Annex A. August 2022. After 4 years of suspension.
Yes.
Well, see, way beyond the benchmark laid down by the Honorable Apex Court, 90 days. So in fact, this order is to cover up the inaction on the part of the disciplinary authority and to circumvent this proceeding itself. So this cannot be viewed as an extension passed within time. So my humble submission, my lord, we have framed the brief written argument. We are ready to submit it, my lord.
So 2 weeks?
Lordship, yes. Even in Ajay Chaudhary, which has been relied heavily by the petitioner, Lordship Supreme Court did not reinstate.
That one. That
Lordship
one
will.
The law was
I'll make a note of argument, Your Lordship.
When the matter was called up, the respective parties have finally concluded their respective hearing, the respective argument. Accordingly, on prayer made by the parties, the written argument is to be filed within 2 weeks. Within 2 weeks. List this matter thereafter.
Apply a lodge.
Item number 8.
Yes. Yes, Mr. Dev.
Lordship, if this matter can be taken up on 20, Your Lordship.
On?
On 20, Your Lordship, Wednesday.
No objections.
On prayer made by Mr. N. D. Shulai, London AG, not objected to by petitioner. List this matter on 20th.
20th. Apply, Lordship.
Item number 9.
Please, Your Lordship. Lordship, this is
Just a moment. Before we proceed to,
yes,
I think item number 9 will be the last item.
last item on today's list. The others are adjourned, my lord.
Yes, Mr. Yadav, this item number 10, you were not there earlier.
Absolutely.
The other respondent have sought for accommodation.
Right, Lordship, if it can be fixed
Would
together.
Would you?
Yes, better to do it
Prepared
together.
to be heard today, or?
So we'll do it together because it's a connected matter. They've already started the arguments for items number 11, 12, 13. The respondent counsel had already started the arguments. Let him complete, then I'll.
So we'll pass the same order.
Yes.
Can you include down to?
Yes. Highly obliged. Good day.
Yes, Mr. Jindal.
My Lord, Lordship, what is before you today is a second appeal filed against judgment passed by Additional Deputy Commissioner Shillong in an appeal I had filed against dismissal of my suit by suit court, that is assistant to DC. I'll just take a few minutes, my Lord, just to set out the background briefly. Matter, my Lord, originates and starts from page 14 of the paper book, my Lord. Paper book. 1-4. It's a spiral bound.
This is the.
No, it's a spiral bound copy.
Oh, sorry. Yes, paper book. Sorry.
Yes. Page 14, my Lord.
Yes.
This, my Lord, is a lease deed.
Yes. Dated.
That I had entered into with the respondent on 20th March 1923. 20th March 1923. Now, a few aspects from this lease deed requires highlighting, my Lord. First, my Lord, on the first page itself, page 14,
Yes.
somewhere in the middle, my Lord, just below the schedule which is there, I'll read, my Lord. Does hereby lease in perpetuity, number one, the said land covering an area of 10.19 acres, more or less, of upland from 1st April so-and-so to the General Secretary, Sports Section, Shillong Club. Next page, my Lord. Page 16, 1-6. Clause H, my Lord. Subclause H.
Yes.
I'll read, my Lord. The lessee shall, that means I shall, be entitled to relinquish this lease at any time on giving not less than 1 year's notice to the lessor, his heirs, successors in interest or assigns. So essentially, my Lord, I, the lessee, the lessee has been given the right to relinquish or cancel or terminate this lease deed. The parallel right has not been given to the lessor, my Lord. The reason would be, my Lord, because this land was required to set up a golf course, and a golf course has been set up, which is still in operation. So a golf course takes investment takes time. So to terminate the lease deed would be detrimental to everyone's interest. So the parallel right of relinquishment was not given to the lessor, my Lord. Next point, my Lord, is just below the second last line on this page itself. The previous lease, my Lord, the previous lease, which is current till the 31st March 1922, is hereby cancelled. So before this lease, before this 20th March 1923 lease, there was another lease, my Lord. And that lease, the date is important, that lease was valid up till 31st March 1922. Why this date is important, my Lord, will become clearer a little later, my Lord. But this date is important. There was a previous lease valid up till 31st March 1922, my Lord. This was the lease deed of 1923. We entered into the lease deed. The land was handed over to us. We set up a golf course and we developed the land, etc. Matters were going fine, my Lord, for a very long time. Problems started coming up, my Lord, sometime in 2013, page 19, 19. Page 19.
Yes.
Is a letter dated 18th January 2013, issued by the respondent.
Yes.
Now, the first part is there. The second paragraph, my Lord, up below the schedule again, my Lord.
Yes.
No, I'll read the entire letter, my Lord. It's a short letter. I'll start from the beginning. Sir, I, the undersigned, who is the elder Rangbakur of the Thank You Laipo clan of so-and-so, have the honor to state that our predecessors in interest as the owners on behalf of the whole clan had leased out to your club a plot of land situated at Pinthormukra, Shillong, measuring a total area of 10.19 acres, more or less, bounded as below. So, my lord, I'll just pause. There is a clear admission, and there's no dispute also, that in 1923, they gave us 10.19 acres through a lease deed. That was the lease deed which Lordship has just seen. Below the schedule, my lord, that the portion of land on the south, as shown and indicated very clearly in the said schedule above, has never been utilized nor fenced properly, resulting in a massive encroachment. But since the neglected and unutilized portion of the land is still remain with our Thank You Lightfoot clan as the owners, with the trees standing thereon, therefore, we hereby have decided to take back into possession the said portion shown above, which is outside of the schedule leased out to your club. Again, I'll pause, my lord. So, firstly, my lord, in this portion which I've just read, there was an allegation that the southern portion of that leased property has not been utilized by us, and it's not been fenced properly by us, etc. And therefore, the further allegation is that there is encroachment over that portion, over the scheduled land, the land which was given to us. Number one. Number two, there is a clear expressed intention, the language is to take back into possession. Now, taking back into possession, I submit, implies that it is in my possession. They have expressed a desire to take back into their possession. Rightly, wrongly. So, this is the second point that comes out, that there is again an implicit acknowledgement that the land in question is in my possession and they want to take it back to their possession. Then they say, which is outside of the schedule, that land which they want to take back, which is outside of the schedule leased to your club. So first they say the southern portion of the land leased to your club has not been fenced properly, there is encroachment, etc. Then they say it is out, that portion which they want to take back is outside the scheduled land. Contradiction is very apparent. What exactly do they want to say? Frankly, my lord, it's not very clear. Do they want to take back land which they have leased to us, or do they want to take back into possession which land which is outside of the lease? Not very clear. But in any event, this letter was issued, which expressed a desire to unsettle the position which was in place for the last 100 odd years. This was issued in 2013, my lord. Little less than 100, but a substantial number of years, my lord. This letter was issued. Subsequently, my lord, we started noticing that there were many attempts to sort of unsettle the position. Some advertisements were issued in the local newspapers saying that land is available for sale, etc., which indicated that, and these advertisements from the respondent side, which indicated an intention to sort of again, as I said, unsettle the position, etc. We filed objections with the registrar, sub-registrar's office against any proposed transfer, etc. Finally, my lord, we had no other option but to institute a suit. That suit, my lord, starts from page 1 of the paper book. That suit, my lord, was filed in 2013 itself. Page 1, my lord, if lordship sees what exactly is the suit, the cause title, a suit for, page 1, yes. A suit for declaration, permanent injunction and other consequential reliefs valued at so and so. Now, this suit, yes. What did I want from the suit? My prayers in the suit is important. Page 10, my lord. Page 10 is the prayer portion of the suit, of the plaint. Yes. First prayer, my lord. Declaration that the plaintiff Shillong Club Limited is a lawful lessee in respect of the suit property and holds the suit property under a valid perpetual lease deed. I'll just pause, my lord. The prayer is for a declaration that I am a lessee and I hold the land in question under a valid perpetual lease deed. Respectfully, my lord, there should have been absolutely no problem as far as this prayer is concerned, for the reason that they are also in agreement that yes, there is a lease deed, and yes, obviously, evidently, on the face of it, it is a perpetual lease deed. This was the first prayer for a declaration that I am a lessee of the respondents. Second prayer, my lord. Declaration that the defendant or any of his agents, associates, so-and-so, or any person claiming under the defendant have no right to disturb the peaceful possession of the suit property or any portion thereof by the plaintiff in any way and by any means whatsoever. Again, I'll pause, my lord. Declaration that they don't have a right to disturb my possession over the suit property. Now, what is important, my lord, is what is this suit property? I am only concerned, and I cannot stress this enough, my lord, I am only concerned with my leased land, that is 10.19 acres. I am not concerned what happens in and around my property. I have taken 10.19 acres from you. Admittedly, there is no dispute again. I have taken 10.19 acres, and I am only concerned with that 10.19 acres. I am seeking a declaration from the Honorable Court that I am a lessee of that 10.19 acres and I should not be disturbed in respect of that 10.19 acres.
You have a map of the suit land?
Map is not there, my lord. There is no map.
You could have drawn up a map.
There is no map.
Indicating the disputed portion?
The disputed portion, my lord, I can only verbally point out. This is that portion behind Marin's restaurant. There is a forested area. But there is no map as such, my lord. There is no map as such.
You're telling me a local, I can understand.
I know.
If
I'm taking advantage of Lordship's, the fact that Lordship is from here.
You see, yes. As of now.
Yes, my lord.
After so many years.
Yes, my lord.
Invariably, you should have the map of the area.
My lord,
schedule is there, but
my lord. In fact, now that Lordship has posed the question, I do remember, because it's a very old matter from 2013. In between the suit, the proceeding, there was a I will not call it a survey, but there was I will not even call it a demarcation, but there was a site visit, if I can call it that, a site visit conducted, or a sort of site visit ordered by the court. Consequent to that, the survey department had drawn up some sort of a rough map.
Where's that report?
That is not part of the paperbook, my lord. That is not part of the paperbook.
I think so, as to give a clear idea of this. Basically, it's a question of boundary dispute.
Yes, not really. But I get Lordship's point, and map would be important. Maybe it's my mistake in not enclosing it.
Can it be done at this point of time, Mr. Sagreso?
Because if Lordship allows,
it's a second appeal limited issue, my lord. Whether that
no, it's true. But these are facts which are basic as far as the understanding of the court is concerned.
Yeah.
It may not be a formal document for
right. No, understood. If Lordship allows me a few days' time, I'll put it on record. I'll file an additional paperwork.
There's no bearing in the final order passed in the first trial court as well as the first appellate court.
No, that is we are not on law points at this point of time. He is just going through the facts.
Yes. That map was in fact, my lord, that was in fact neither here and there. Therefore, the petition, the appellate also.
See, Mr. Sagreso, what is the basic grievance of the petitioner or the appellant, for that matter, is that there is a land measuring 10.9 acres or so, which was leased out to them.
Yes.
Some portion of the land, according to you, has not been utilized or has been left unattended, which presumably gave you the right to resume it, if I understand it correctly. But to what extent, and what is the exact area of the land sought to be resumed by you, which according to has intruded into the portion
I understand. Lordship wants to know ascertain the exact area of dispute. Now, my humble submission is, my lord, the map is not at all relied by both the court below. and neither part of the discussion in the final judgment, operative part of the judgment.
In fact, that
So
was
if that is
the
part of
reason
the,
I didn't include
yeah,
it.
if that is the part of the map is part of the discussion and final decision, and map is not here, Lordship may kindly peruse it. But according to me, my Lord, since both the trial court or the court below has no, my Lord, emphasize on those, it may not have a bearing in this. So my humble submission today is, my Lord, if Lordship proceed the matter, and if in the course of the hearing, if Lordship finds that it is really essential, then Lordship may consider. As of now, my Lord, when my friend is opening up the fact of the case, my Lord, at this stage, my Lord, it may not require.
Lordship, if
I would show both the judgments. It has no bearing at all.
Lordship, I completely agree with Mr. Aso to the extent that both the courts below have not really referred to the map. But if I've understood Lordship's mind correctly, at the moment, Lordship just wants to get an idea of the physical layout of the land,
Exactly.
which part belongs to who, etc. That map is there somewhere in my file. If Lordship wants, if Lordship gives me 2-3 days, I'll file an additional affidavit to bring it on, paper book to bring it on.
Well, like I said, if what as Mr. Sangrasu has
Yes.
rightly pointed out,
Yes.
if both the court below
Yes.
have not called upon, you see, production of the map or
No one referred to it. No one referred to it.
it's nobody's case, no doubt.
Yes, yes.
But the only thing is, for the satisfaction of this court, you can file an informal sketch map.
Very well, very well.
Nothing to,
Right, and if
maybe
Lordship
nothing to
wants
do with the
peruse,
case.
yes.
Understood. Understood.
Neither it will improve my case nor my friend case, even if Lordship peruse it.
But Lordship
If
wants to know
Lordship
the
decide, we
physical
can.
layout, which is fair enough. Lordship allows me 2-3 days. I'll put it on.
You can do that in the meantime. Please continue.
So, should I continue this? Okay. Lordship, as I was submitting, the purpose behind me filing the suit was only to ensure my rights over that 10.19 acres, nothing else, my lord. Now, suit was filed. In response, my lord, WS was filed by the respondents. Page 33, my lord.
Page
33, 33.
Yes.
Page 33, my lord, was the WS. Before going into the WS, my lord,
Yes.
before going into the WS, one extremely crucial aspect of the matter needs to be highlighted and noted by this honorable court is no counterclaim was filed. No countersuit was filed by the respondent in any respect. It was only a WS which was filed. So I raised a claim, or I filed a suit for the 10.19 acres. No countersuit was filed, counterclaim was filed in respect of the 10.19 acres or in respect of any other portion of whatever land they that may have been standing in their name, my lord. So WS was filed, more or less a standard WS. Important portion, my lord, is at para 14, next page, my lord. Para 14, 1-4. The second paragraph, the second portion, my lord, the second unnumbered paragraph. I'll read that part, my lord. In reply, it is stated that the predecessors in interest of the defendants on 20th October 1914, this date is important again, this is where their defense is contained. They are saying it is stated that the predecessors in interest of the defendant on 20th October 1914 leased 16.91 acres of their land to the predecessors in interest of the plaintiff's club. Thereafter, due to bona fide requirement and on mutual understanding, 6 acres of the land situated to the south of the leased land was taken back by the predecessors in interest of the defendant, and a fresh lease deed dated 20th March 1923, that is my lease deed, my lord, was executed only for an area of 10.91 acres as in Annexure 1 of the plaint. Few days after execution of the fresh lease, it was discovered that the boundaries in the fresh lease to the south remained unaltered like the previous one of 1914. The then predecessors of the defendant raised this issue before the then members of the erstwhile Shillong Sports Club for causing necessary corrections to the deed. However, the then members of the plaintiffs' club assured that they too are men of words who keep their words as well, and that they would never question the landlord's title nor encroach into the predecessor's land beyond the allotted 10.91 acres on the mere minor technical defect in the document, and the predecessors of the defendant accepted that assurance. I'll pause here. So, Lordship, this is the first time that the real case or the projected case has come forward. In 2013, when that letter was issued, there was no such reference that in 1914 there was a lease deed for 16.91 acres, that after that we took back 6 acres, then a new lease deed, etc. Nothing was there. It was just a plain simple letter saying we've given you 10.91 acres, we are taking back the southern portion. That was all. So now we have a new case that has been set up by the defendant, which is that in 1914, according to them, they gave us 16.91 acres. Subsequently, 6 acres was taken back by them, and we were left with 10.91 acres. That was the area that was covered under that first document, the first lease deed of 1923, which I had shown Lordship. Moving on, my lord, on the same page, the last paragraph. Since 1923, the said portion of 6 acres remained in the absolute possession and occupation of the defendant and his clan, where he had also leased certain portions in and around the said land to different tenants by issuing pattas to them without any objection from the then members of the plaintiffs' club, as assured by their predecessors. Now, one more very contradictory assertion in the WSS, that according to them, since 1923, that 6 acres which they had apparently taken back has been in their absolute possession and control, and they've in fact leased certain portions to others, my lord. Now, simple question that will arise is, if that 6 acres was indeed, that 6 acres on the southern side of the suit property was indeed in your absolute possession and occupation, then where was the need to issue that January letter, that January 2013 letter saying, I am going to take back into possession? You say in the WS that it was already in your absolute possession and occupation. Prior to that, in your letter of January 2013, you say that I am going to take back. There is an evident contradiction. There is an evident contradiction. That contradiction has still now not been resolved. And their response to that January 2013 letter, where they say that I am going to take back 6 acres, is in para 17 of the WS. Now, yes, it is less of a response, more of an excuse that they have placed. How to justify that January 2013 letter? I'll read my. That the plaintiff was found to have surreptitiously constructed cowshed and other sheds housing the club's chokidar and others to the south of the lease land and on the north of the defendant landlord's land. However, the defendant being a layman and an old aged person with memories failing him, he was in no position to properly draft the wordings in the said letter dated 18th January 2013. So their defense or their response in respect of that, I would say, damning letter of January 2013 is, I am an old man, I did not know what I was writing. This cannot be a response, this cannot be a defense of any sort. In January 2013, you have admitted the land in question is in my possession. You have admitted, you have stated that I am not using the land. That's why you are taking back the land. Now you come up with some other defense, and to justify the contradiction, you say, I am an old man, I do not know what I did not know what I was writing. That cannot be, my lord. That cannot be. In any event, this was the WS which was filed. Matter proceeded, and as I submitted some time back, as I pointed out some time back, there was no countersuit which was filed. That being the case, witnesses were examined. One witness from our side, one witness from the other side, my lord. The evidence, my lord, is at page 55, my lord. 55. Before that, if Lordship kindly allows me, Lordship may kindly look at page 39, 39.
Yes.
Now, page 39 is the 1914 lease deed, which they are banking on. 1914 lease deed. I'll just highlight two aspects from the lease deed, my lord. On this page itself, the last portion, last para,
Yes.
do hereby lease the said land covered under in area of 16.91 acres more or less for a term of 10 years from the 1st April 1914 to the 31st March 1924 to the secretary to the Shillong Sports Club. This is crucial, my lord. The lease of 1914 was in favor of an entity called Shillong Sports Club, not Shillong Club. Secondly, Lordship, the pages are not very clear. If Lordship looks at the typed copy, that is at page 42A. 42A.
Yes.
So, as I had highlighted, first aspect is the lease of 1914 was to Shillong Sports Club. Second aspect is in the next page.
Yes.
Next page. The date of this lease is important. Of this 1914 lease, last portion, my lord, in witness whereof.
Yes.
In witness whereof, I so and so of so and so do hereby set their hands this 20th day of October 1914.
Yes.
So the date is important. Why the date is important is evident from page 16 of this paper book, my lord, 16. So date of 1914 lease is 20th October 1914, page 16, my lord, 16. Which is my lease. The portion which I had highlighted previously, the second last line, the previous lease which is current till the 31st March 1922. So there was a previous lease prior to my lease, but that was only till 31/3/22. This lease, 1914 lease, makes no such reference. It is a lease which starts from October 1914 and it is for a term of 10 years. That is at page 42A. Second paragraph, for a term of 10 years. Does hereby in perpetuity the said land covering an area more or less for a term of 10 years from 1st April 1914 to 31st March 1924. So this 1914 lease was till 31st March 1924. The lease referred to in my lease, the previous lease, was till 31st March 1922. So my lease of 1923 is not referring to this 1914 lease. It is referring to some other lease. This aspect is crucial. This aspect was considered and appreciated by the suit court when passing the judgment. I'll just come to that shortly. But this is an important aspect. Firstly, 1914 lease was entered into with someone called Shillong Sports Club, number one. Number two, the 1914 lease was till 31st March 1924. Evidently, it is not the same lease which has been referred to in my lease of 1923. My lease refers to a lease which ended on 31st March 1922. Matter proceeded, issues, etc. were framed, evidence was led by the parties.
Where's a copy of this lease?
Of the
31st March 1922?
That copy is not on record, my lord. That copy is not on record. Because it was cancelled, my lord. There was no...
May have been cancelled, but it would be relevant in as much as in the said lease there may have been a schedule.
True, my lord. True, my lord. That schedule would be a continuation of the same 1923 schedule, my lord. The schedule which is there in the 1923 lease.
And what about the schedule of this 20 October 1914 lease?
If lordship compares the two schedules.
Because here, you see.
Yes, my lord. Yes, my lord.
Is it matching?
It appears to be matching, my lord. But if lordship looks at the schedule, unfortunately, it is not a precise schedule. If lordship looks at either of the schedules, East Family Kapo land of so-and-so, thank you. North Family Kapo land of so-and-so Rumlong. West, my own clan land. South, Polo Ground. Now, the exact boundaries are can never be ascertained from these schedules, my lord. Unfortunately, this was the way schedules were drawn up at that time. So schedules maybe
that is why.
Yes, madam.
The
map becomes
the trial court.
Yes, madam.
Yeah. Should have taken care of this issue and call upon the parties to conduct a survey, get the the proper demarcation with all the area indicated and all those things. That was not done.
Lordship is right. That may have been the best course to adopt. But here, Lordship will kindly appreciate the nature of the suit that we had placed before the lower court. The nature of the suit sought a declaration in respect of a document, 1923 lease, about which there was no dispute. There was no dispute between parties that 1923 had actually been entered into for a period for perpetuity, etc., covering a period of 10.91 acres. We only sought a declaration.
See, till the time you had filed the suit, there was no dispute, no doubt.
Yes, madam.
But the dispute, apparently, noticed by you, is when the claim was made for the southern part.
Yes, madam.
Which has affected your 10.9.
Which would have affected.
Which would have or has, whatever.
Right. Yes, madam.
So, see, therefore, it would have been very, necessary.
Yes, madam.
For the proper demarcation to be made. And
Lordship is right. And
you see, a site inspection would have solved the problem.
My lord, there was a site inspection conducted, but nothing came out of it. I would assume for the reason of the ambiguous nature of the schedules, because from the schedule, it's frankly impossible to locate this land, 1914 land or 1923 land, on the ground from these schedules. So that became impossible to locate, and I would respectfully also submit, my lord, that what Lordship is saying holds true and would have held more strength if it was indeed a boundary dispute, my lord. If I was saying that this is my land, he is encroaching into my land, or there was a counter suit to that effect that they have encroached beyond that 10.91 acres, if it was a true boundary dispute in the truest sense of the term, then definitely a site inspection, proper demarcation, etc., would have more or less solved the matter, my lord. But here, my lord, we have only asked for a declaration. This is our document. Please declare this to be a valid document, and that we hold 10.91 acres validly as lessees. That was the only thing that was sought. As I was saying, there was no counterclaim filed. If a counterclaim had been filed to the effect that we have encroached upon their property, we have gone beyond 10.91 acres, then definitely without a site inspection, without demarcation, etc., matter could not have been adjudicated in any manner. But the nature of the dispute, the nature of the list that was put before the lower court was a slightly different kind. It was not really a true boundary dispute.
It may not be so. It would appear that the defendant, as you have pointed out,
yes,
has sought to resume a portion of your land.
Of the 10.91. Yes, my lord.
So that by itself, you see, would alter your the schedule of the land.
I would again, very respectfully, my lord, I would beg to differ for the reason that if so, the defendant has been claiming, it appears, that a portion of my 10.19 acres. Now, I have gone to the court seeking certain declarations on the 10.19 acres on my lease deed. If the declaration has been granted in my favor to the effect that I am a lawful lessee, etc., and consequently they have no right to disturb my 10.19 acres, their claim such as it was, my lord, would have died, would have died a natural death, because they claim, from at least from the letter, it is evident that they wanted certain portion back from that 10.19 acres. So that claim would have been defeated if there had been a declaration in my favor that yes, you have a valid lease deed, and consequently they have no right to disturb your 10.19 acres, my lord.
Yes, by the way,
yes, ma'am.
Sorry to divert.
Yes, ma'am.
The letter,
yes, ma'am,
whereby they say that they are resuming the land.
Yes, ma'am.
In other words,
yes, ma'am.
Have they given an indication, or have they specifically stated to what extent, what is the area that they sought to resume?
No, my lord. If Lordship looks at page 19, the second portion, first the schedule. The schedule is the same as the lease deed, 1923 lease deed, plus of course the 1914 lease deed. Then they say that the portion of land on the south, as shown and indicated very clearly in the said schedule, above schedule, has never been utilized. So they are claiming, the extent of the claim is not clear, my lord. They are just saying the southern portion. So southern portion, where do you stop, my lord? It's a very unclear claim. What we could understand, and the reason we went to the court, is that
have you made any pleadings as regard this aspect?
Yes, my lord. In our plaint we have, my lord.
There was no clear demarcation of the.
In our plaint we have challenged this letter. That there's absolutely.
You have challenged letter. No?
Yes, ma'am.
But to this, specifically as far as their claim is concerned, if a certain portion.
Okay.
As to what would constitute the certain portion.
Okay.
Whether it's 1 acre or 10 acres.
If Lordship allows me to read my pleading in respect of this letter, that is at page page 6, I think. No, sorry, one second. Page 5, my lord, para 10 of my plaint.
Yes.
Para 10, my lord, quickly go through, my lord. That the plaintiff club was shocked and surprised to receive the letter dated so and so, issued by the defendant in his capacity as Rangbakur of the so and so clan. The contents of the said letter can be succinctly summed up as under. The defendant acknowledged that the suit land was leased out to the plaintiff club. However, the fact that the lease was a perpetual lease to operate for all time to come has been ignored by the defendant. The defendant acknowledged in the said letter that the suit property is in the possession of the plaintiff club. 3. The defendant falsely alleged that the southern portion of the property is unutilized by the plaintiff club. 4. Defendant communicated a decision of the Thank You Light for Clan to take back into possession the said southern portion of the suit property and has asked for amicable handing over possession of the Thank You Light for Clan. 5. Defendant has asked for an enhancement of the lease rent being paid by the plaintiff club, etc., etc. Para 11, my lord. Next. That the contents of the above letter dated so and so was surprising because the letter was based on an incorrect assumption that the plaintiff club was not utilizing the southern portion of the suit property. The true fact of the matter is that the entire suit property was being utilized and used by the plaintiff club. Furthermore, it is respectfully and humbly pointed out that in law, non-utilization of leased property by the lessee, even if true, does not accord the right on the lessor to cancel the lease. This is more true in the circumstances of the present case, whereas highlighted above, it was only the plaintiff club which was given the right to relinquish the lease deed and no similar right had been given to the defendant, so-and-so clan. By seeking to take back into possession a certain portion of the suit property, the defendant was in effect attempting to nullify the said lease deed. It is respectfully but firmly stated that the defendant, Thank You Light for Clan, does not have a right to do so. This matches what has come from Lordship just now.
What is the response in the written statement to this?
Yes, I just read that out. That is at para 1 minute. Para 1 minute. Uh, 17, my lord.
Page
35. para 15 first. Para 15, they are referring to para 7. The averments, the pleadings which I just read were at para 10 and 11. So first, para 15 of WS, they refer to para 7.
Para 7, yes.
Para 16, this is in reply to para 9. Para 17 would be reply to para 10. It's not, it is written. So para 10 reply is that the plaintiff was found to have surreptitiously constructed cowshed, etc., to the south of the leased land and on the north of the defendant's land. However, the defendant being a layman and an aged old person with memories failing him, he was in no position to properly draft the wordings in the said letter dated 18/1/2013. However, the bona mistake and innocence of the defendant will not confer upon the plaintiff's club to take advantage of the same like any other opportunist before the court of law. This is in reply to para 10. In reply to para 11, where I further pleaded against the letter, that letter, that the averments made in para so and so of the plaintiff frivolous, malicious, etc., there's no specific response at all. There is, Lordship has seen, there is absolutely no
Puchu, yeah. I think I've been called already. Oh, Chief. This is a very funny situation we have. As I said earlier, you see, this is because of the quorum that we have.
Yes. We understand.
Court with 4 judges.
Yes.
What do you expect?
But
very, very sorry to inconvenience.
No, please don't apologize now. This is
4 minute बाद.
4 बजे बाद.
So
4 minute का बाद. So can you wrap it up in 2 minutes?
I don't think so, my lord. I don't think so. I can try, but I don't think.
Can you do the second half or subject to lordship?
Monday.
Not Monday.
Tuesday. What else can we?
Come to that case. Come to that case. Next. No, zero.
Or Tuesday, Wednesday, whichever.
We'll take it up on 20th then, Wednesday. Yeah. Oh. Then it'll be 21st then.
21st, Thursday.
20th I have another DB. Mr. S. General and Counsel for the appellant has further proceeded with the argument, with his argument as far as the appellant is concerned. However, the same would resume on the next date fix as agreed to by the parties. This is matter on 21 for further hearing.
Thank you.